You're welcome to the Policy Council. My name is Okwemi Agbaje. Today I engage strictly on legal issues, on a lot of issues involving the interpretation of our federalism and our constitution. I do this with the Honorable Attorney General of Lagos State, and we'll go through a lot of issues that test the limits of federal vis-a-vis state powers. Enjoy the program. You're welcome back to the Policy Council. Today my guest is the Honorable Attorney General of Lagos State. He's been here before. He's a former special advisor to the Lagos State Governor on taxation and revenue. He's from the academia, was senior lecturer and sub-dean at the Faculty of Law, University of Lagos. He's also served in government as special assistant and later senior special assistant to a former Attorney General of Lagos State, Professor Yemi Osinbajo. Today we will explore various issues around judgments, around federalism, and around the position of the Lagos State government. Mr. Adeekpaye, you're welcome to the Policy Council once again.
Thank you.
So I know that there's a particular judgment you have on the hotel segment, on hotels and hospitality sector.
Yes.
At the Supreme Court.
Yes.
And involving the Lagos State government, and in effect other state governments, and the Nigerian Tourism Development Authority.
Yes.
Well, tell us about that judgment and its implications.
Well, there were two court actions. One was filed by the federal government, that is the Federal Attorney General against the Attorney General of Lagos State. The other was filed by the Attorney General of Lagos State against the Federal Attorney General. So there were two issues. One was the control of the tourism industry, especially the hotels, restaurants, fast food outlets, and so on. Because at the time, the Tourism Development Corporation, that is the national body, was trying to register them, grade them, and so on and so forth. And we said no. That if you look in the Constitution, the jurisdiction over these outlets resides with the State House of Assembly. So we had that challenge. The other one was the consumption tax law of Lagos State, which was challenged by the Federal Attorney General on the assumption that the Lagos State House of Assembly didn't have the power to make that law. So those two issues had to be determined by the Supreme Court, and they were both resolved in favor of Lagos State. In essence, the court said that the control of tourism in Nigeria was within the purview of states, and that it was also the states that had the competence to enact a tax law that would affect operators in that industry.
I mean, one of the things I've noticed is I've even seen that agency, the Nigerian Tourism, opening regional offices. I've seen one on Obafemi Awolowo in Lagos. So my worry is this: if they don't have jurisdiction over tourism and over hotels, why are they opening regional offices across the states? And do you see explicit signs that the NTDA is complying with that judgment?
Well, what we've seen is that at least they are no longer going after the hotels for registration fees, licensing fees, and so on and so forth. So they've stopped that. And then the contention that our hotel occupancy and restaurant consumption tax law was illegal is now resolved. So nobody is quarreling with that anymore. But otherwise, it appears that the NTDC is still carrying on much as before. But then I think it's up to the states now to decide which room, if any, they want to allow to any federal agency. Because the court said in that decision that it was clear from the legislative list in the Constitution that what was reserved for the federal government was the control of tourist traffic.
into the country
into
of necessity.
Yes,
because
so,
that's almost similar to immigration.
Exactly. So if tourists needed a visa to come into the country, of course, that would be within the purview of the federal government. If their stay here was to be regulated, as to number of days or months, then it's within the purview of the federal government. But as of necessity, the actual tourist attractions, the places where tourists go, they must be within states. And it is states that must develop those places. And I think that was what that judgment recognized.
Okay, excellent. Like I said, we're going to be talking through a lot of these things and enlightening ourselves and the public. Let's take a short time out and I'll talk to the Honorable Attorney General about maybe the toll gates, which is something I know a lot of Lagosians would want to hear about. We'll be right back. You're welcome back. It's still the Policy Council, and I'm still with the Attorney General of Lagos State, Mr. Ade Ekpaye, a lawyer, an academician, and a senior government functionary. Mr. Ekpaye, so let's talk about the Lekki-Ikoyi link bridge, which is another contentious issue.
Yeah.
You have a well-known human rights legal practitioner, Mr. Ebonlu Adegbowo, who has taken the responsibility to challenge your right to toll that road, and indeed the earlier one on the Lekki-Ekpe link bridge. But there's some controversy over this. A court seemed to have ordered you to desist from charging tolls on that road, or he said it was illegal for you to charge, and you haven't complied with that. Tell us the Lagos State government's perspective on that matter.
The court reviewed the claims of the applicant, and there were 10 declarations that he asked the court to make. And there was one injunction. In addition to the 10 declarations, he wanted the court to make an injunction to stop Lagos State government from tolling that bridge. And his contention simply was that the bridge should not have been constructed because it was the National Inland Waterways Authority that could do anything on the waterways, and we went on to construct without the concurrence of the Waterways Authority. Therefore, it was an illegal bridge. And he said, having constructed it and considering that it was an illegal bridge, we shouldn't toll it. Because tolling interfered with his freedom of movement. That's exactly how he put it, and that it amounted to discrimination against him and so on and so forth. Well, in the course of the hearing, it became apparent that our contractor, that is Mrs. Julius Baja, had actually
obtained approval.
NIWA 10 million naira. After several, because it was all about money really, NIWA wanted, I can't remember the sum, they haggled, and when it became apparent that the project was going to be stalled, a multi-billion naira project, Julius Baja paid 10 million. Okay, so once that fact got into court, the court used it in coming to a conclusion that, well, because Lagos paid NIWA, then Lagos had considered and had
the authority of NIWA.
Conferred authority on NIWA, that NIWA was the only agency that could control all the waterways. So that was part one of the judgment. The second part was that the law that we cited as authorizing tolling in Lagos State, that is the Public-Private Partnerships Law, which actually expressly covered public infrastructure and public assets, could not apply. And this is in essence what the court said, could not apply in this case because that bridge was not shown to have been built with private sector capital contribution. So those were the two major legs of the decision. But the aspect that may interest you most is that of the 10 declarations sought by the applicant, none was granted. Of the single injunction that he asked the court to make, it wasn't made. So our view from the word go was that there was no court order, and the court said that our law did not cover tolling, but it didn't make any order that we should stop tolling. So, and at any rate, we took the position that even if an order had been made, we were still within our rights to appeal that order. And the law is well settled that we didn't have to obey an order which we had appealed at the appeal court.
Whether or not there was a stay of execution.
Whether or not, because at that time we had also applied for the stay.
Okay.
So we had an obligation to
and file an application.
And the court ruled on that application, agreed with us that even if there was an order, we were not bound to obey it because we had appealed and we had filed an application to maintain status quo so that nobody disturbs. And the court did now order that there should be no disturbance on the bridge pending the hearing and determination of the appeal. Okay,
but let me ask you something I found as an individual. If the court felt, if the court's judgment or position was based on its assumption or position that the law did not give you the right to toll, Lagos State government, would it have been possible for Lagos State government simply to enact another law now explicitly?
Well, we have, is an option, you see. We believe now that the law we already have expressly mentioned public assets. Okay? So the court was relying, I think, more on the title.
The title of
which
the
said
law.
Public-Private Partnerships Law, and just came to the conclusion. We believe that if the court had interpreted the phrase public asset or public infrastructure, it would not have had any difficulty applying it to that bridge. And then again, one major reason for our appeal is that we quarrel with the assumption that because Julius Berger paid 10 million, therefore we had conceded to new authority. This was a constitutional power, or at least a statutory power, which cannot be compromised by. It's like saying because the applicant also paid the toll, therefore he had conceded to Lagos State.
Which takes me to the next issue we'll be discussing after this time out. The real constitutional issue between you and NIWA over the control of inland waterways. We'll be right back.
My name is Onyema Kinzago. I live in Lagos where things are getting better every day.
Our school has just been renovated.
And they give us free notebooks too. Going to school is easier and safer for students like me because I can cross the highway using the footbridge. And I use the BRT bus, which is fast, convenient and free for students like me. I enjoy looking at the beautiful streets on my way to school. And the many street signs tell me where exactly I am. When I get to Basic 12, the government will pay the fees for my GCE and NECO examinations. I am happy. My mom and dad says all these good things are happening because they pay their taxes. I hope to pay my taxes when I grow up and start working. Have you paid your tax?
Pay your tax. It's your civic responsibility. It's your duty. It's the law.
You're welcome back. It's still the Policy Council, and I'm having this fascinating discussion with the Lagos State Attorney General on a series of legal issues involving the Lagos State government. And we turn to the issue of inland waterways, which was an ancillary issue in the toll gate issue, but which was have
major
a
in another case. Yes,
issue with the federal government. So let's talk about that. Okay. Well, what's your contention? What are the issues? And how is that shaping up?
We are particularly concerned about the waterways because Lagos State has the smallest land territory in the Federation, 3,557 square kilometers. It's the smallest, smaller than Abuja, smaller than any state. And 30% of that is water. Okay, so if you see that we are agitated about controlling our waterways, that fact should be borne in mind. And then again, because of the congestion, the population density in Lagos, and we are talking now of a figure above 20 million, obviously the public transportation profile of Lagos must now shift significantly to water transportation. And what does water transportation require? A lot of dredging, a lot of building of ports for the ferry terminals and things like that, which we are trying to do. So this brings us into conflict with NIWA because the National Inland Waterways Authority insists that it has the power to control all waterways in Nigeria. So our contention in the matter is that if you look in the Constitution, it is clear. Shipping and navigation, okay, in Nigeria is within the purview of the National Assembly. And National Assembly could give that power to NIWA. And we think shipping is about ocean going.
Of course.
Yes.
For
and,
common sense.
Yes. In fact, it says maritime shipping and navigation. But it makes some addition. After using that phrase, it also includes such inland waterways, such waterways that may be designated by the National Assembly as interstate or international. So the question
again, for understandable reasons, if a waterway is between two states, there may be a dispute between the states.
Yes.
And then you may need federal
exactly. So international or interstate. Now the point is, as we are here today, if you look in the laws of Nigeria, there is nowhere where the waters of Lagos State have been designated international or interstate. What you will find in the NIWA law is designated as federal navigable waterways. That's not what the Constitution contemplates. So that simply is our argument. And of course, the argument on the other side is that all waterways belong to NIWA. Now, let's even put that aside, okay? Because control of waterways is one thing. Control of transportation on the waterways is another. We are talking of a case instituted by boat operators. Now, the question there will be whether boat operators should be accountable or subject or pay tax to the federal government. It's like saying Danfo operators using the federal roads, because there are some roads that are federal roads, should now be subject to Abuja in terms of their licensing, in terms of their operation. So that's another matter that we are fighting as a separate issue. Of course, as you indicated, the Federal High Court ruled against us on both grounds, and we are now in the Court of Appeal on that too. We think ultimately is a matter that has to be resolved by the Supreme Court, because we feel very strongly about the fact that you cannot regulate, in any federalism, you cannot regulate boat operators from the federal government. No.
That would make some sense to me. Let me ask you very quickly about freedom of information. There have been some, I've read in the newspapers, and even I've had some solicitation from civil society concerning that issue, trying to draw the attention of this program to that issue. What's the Lagos State government's position on freedom of information?
Okay. Now there is a Freedom of Information Act, which is hard one. I know it's a federal law, and I know all the agitation and the efforts that went into getting it. But now we have that. The question is whether it also applies in the states. And of course, I will look in the Constitution to see the way in which the power over public information had been demarcated. And it's there clearly under the concurrent list. It says if it is public records of the Federation, then the National Assembly will make the law, which it has made in the Freedom of Information Act. Then it says if it's public records of the states, it's the State House of Assembly that, and to me that makes perfect sense, because as we administer the state, we generate information, some confidential, some not. And it will be odd indeed for a federal law to determine what will be confidential to the state government or not. That cannot happen in a federalism. And some people talk about covering the field. No, not here, because the field has been well demarcated. So we are insisting that Lagos State has the right to make its own public freedom of information law. And there is indeed a bill in the House already. But if we push all that aside, the question really at the end of the day is whether anyone needs information from Lagos State, which ought ordinarily to be made public, and is not getting it? And I believe the answer will be no. The one that has sparked this controversy was the World Bank loan for the ECO project. Yes. The reporting processes are very strict, and they must apply. If you must begin to draw down, you must continue to draw down the loan. Even there are publication requirements. And we have indeed published in the newspapers how this money was being spent. This is simply not money that could be taken and spent in a way not contemplated by the contract. And the way it's even being spent can be seen all over the place, because this is money going directly to schools to enable them run things which were hampering their operations. So, and again, World Bank has its own policy, open. So you can even go to the World Bank and access the manner in which, the purpose for which the loans were being given, the manner in which they were being spent, everything is open. So it's a wrong candidate for this controversy, really.
Excellent. Let's take a short time out. I'm enjoying this conversation with Mr. Adekpaye, Attorney General of Lagos State. We'll be right back. You're welcome back. It's my final segment with Mr. Adekpaye, Honorable Attorney General of Lagos State. We've looked at this judiciary judgments relating to inland waterways, to toll gates, to hotels. Now we'll talk about VAT, the value-added tax, in which again there's some legal controversy between the Lagos State government and the federal government. And I think there was an adverse judgment against you in relation to that.
Yes. We have had this controversy for quite a while. Actually, since 1999.
Yes.
Because the value-added tax decree, as it was then, was promulgated during the military era. At that time, the federal military government could make laws on any subject whatsoever. But by the time we transited to constitutional rule, it became important to review it again, because consumption tax, sales tax, value-added tax, whatever you choose to call it, had never in Nigeria been one of those taxes reserved for federal jurisdiction. Okay, so we had challenged it informally, officially, and but eventually we got to court. And when we got to court in 2008, all the states were involved, and some took a position, some were against, and everything. And that's how it was. But
you would have a greater stake in VAT than many states.
Yeah.
Because you are a net contributor.
Yeah, definitely.
So if somebody gets more than he would otherwise get, if it was a state law, he probably would not be on your side.
Of course. And really, I think it boiled down to that when the agreements were submitted. But unfortunately, the Supreme Court declined to hear the case. So it wasn't a case of a decision against or for. And it made some interesting pronouncements regarding the interpretation of the original jurisdiction of the Supreme Court. I think section 231.
Okay, the Supreme Court said we don't have original
jurisdiction. Yes, that we only have original jurisdiction in a matter between the federation and a state. And this is a matter between a state and the federal government. That distinction, I've been reflecting over it. It does change the law as we know it, because we've had several disputes, straightforward, between state and federal government. The one about hotel that we talked about is one of those, and the Supreme Court heard it. But this time it said that it wouldn't. And it also interpreted section 251, which gave jurisdiction to the federal court, and suggested that a case, because this was revenue of the federal government, ought to have gone to federal court. Again, we don't think it was revenue of the federal government. That begged the issue. That was why we were in court anyway. But be that as it may, that is the final court. We can only criticize for academic reasons. The long and short of it is that the court said it did not have jurisdiction to take that case. So we are back exactly where we were.
And do you intend to pursue that case now through the Federal High Court?
For now, no. That decision hasn't been made.
Interesting. All of these matters we have discussed show the tensions between, it highlights the issues around federalism.
Yes.
Devolution of powers. Yeah. How do you reflect on all this? What would you like to see going forward? What implications do all of these arguments have for?
The kind of tension we see here, take gambling, lotteries, another issue that's between us. Now, someone will go to Abuja, get a federal lottery license, but he won't go to other states. He will come to Lagos. I'll go to Rivers. So really, you will see that some states have more at stake in trying to redress these issues. But as you have said, federalism, that is it. In the US, that is what goes on. The powers have to be interpreted regularly because there are always areas of overlap or apparent overlap, which is up to the judiciary to correct. So we have the faith that ultimately the judiciary would resolve all of these matters. And it is if at the end they are unable to resolve it in a manner that satisfies everyone, then we talk of review of the Constitution itself in order to make things clearer. But I think the principles are fairly well settled. Local matters should be left to. So both operators in Lagos, whatever was going on within Lagos, not interstate or international, should be Lagos affair.
Interesting, exciting, interesting, controversial, but probably part of the building blocks of building a stronger union.
Yeah.
Mr. Akpaye, thank you for coming on the Policy.
My pleasure.
We'll be right back. As you can see, I very much enjoyed the conversation with Mr. Akpaye, and I hope you did too. But beyond enjoying it, it was a highly illuminating discussion around the issues, the tensions between federal and state powers within the 1999 Constitution. My take is this: you are either a federation or you are not. There's a logic to federalism, and like my guest stated, that logic is that powers should reside where they are best used. So local issues should reside with local power, with the local tier of government. But that is why we have a judiciary. And that is why the rule of law allows us to test all of these controversies through the judicial system. And where the judiciary does not resolve the issue, then the political process will address them. Thank you very much for watching. See you next time.